Good afternoon, everybody, and thank you for joining us in our COVID contracting webinar series. My name is Jennifer Schaus, and we are coming to you live from Washington, D.C. today. Today we are covering employment law issues for government contractors in the face of COVID-19. We thank everybody for registering, and we thank our speakers for participating with us today. A quick blurb about us. We are based in downtown D.C., as I mentioned. Provide professional services for government contractors. This includes anything from proposal writing, pricing assistance, compliance, GSA schedules, 8A certification, and other back office contract administration services. We've got a host of webinars on our website and on our YouTube channel. I think right now the tally is 350 plus recorded complimentary webinars. We cover practical strategies and government contracting issues on Wednesdays, every Wednesday at 12 o'clock. That's our Webinar Wednesday series with guest speakers, most of which are government contracts attorneys. And we do a series on Fridays covering the FAR. So each part of the FAR, 52 weeks in the year, and including the reserved parts, we've got about 52 parts of the FAR. So this next Friday we'll cover FAR Part 19, which is, I think we're in about the 19th week of the year, and that is the small business programs. All the links to those are on our website, and again, those are all complimentary. If you miss the actual webinar, you can go to the YouTube channel or back to our website to get the recording. We've got some links here to various government department or agency websites that should be helpful to you in this COVID contracting era. Obviously, the Disaster Loan Program has its own issues, but you can get some updates here on this link. The Defense Production Act, we did a webinar on this, I believe it was 2 Fridays ago. You can find actual information here. If you're looking for the webinar, go to our website and navigate to the COVID contracting section. The CISA link is here. IRS tax relief information, GSA updates and activities, including the exceptions that they've made on trade agreement acts. Department of Labor resources, which some of these will be covered today. DOD's response, the OMB memo, which kind of kicked things off way back when. And again, today's webinar is being recorded, so if you're coming in late, the recording will be sent to all participants. And the agenda is laid out here, pretty simple and straightforward. I'm going to introduce our speakers. They'll share a few words about just the COVID contracting in general. We've got a couple questions that you guys sent us. I believe we've got 14 in total. And then we'll do a wrap up, and our speakers' contact information will be provided as well. So ladies first, we've got Meryl Renaud, who's an employment attorney over at Miles and Stockbridge. And Meryl, thank you so much for joining us. I'll hand the floor over to you to say a few words to our audience.
Thank you, Jennifer, and thanks to everyone for joining me as I self-quarantine. I'm an employment attorney at Miles and Stockbridge, and I am in our Tyson's Corner office. We are a Mid-Atlantic region law firm. We have approximately 20 employment attorneys handling all aspects of the relationship between the employer and the employee. And of recent, we are a COVID-19 employment firm because this seems to be taking up the majority of our time, as it is probably yours these days. So I look forward to talking to you a little bit more about employment issues during this COVID-19 pandemic.
Great, thank you so much, Meryl. And now over to Pete Duncan, who's also an attorney at Miles and Stockbridge, focused on government contracts. Pete, thanks so much for joining us, and I'll hand the floor over to you.
Thank you, Jennifer, for the opportunity to talk today. My name is Pete Dungan. I'm a government contracts attorney with Miles and Stockbridge in our DC office. I advise government contractors and subcontractors on a variety of issues, including disputes such as bid protests and contract claims, regulatory compliance concerns, internal investigations, intellectual property, and other matters. In the last month and a half, of course, since the stay-at-home orders began, We've been advising clients on COVID-19 issues, including the various reimbursement schemes, especially Section 3610 under the CARES Act. So very happy to talk to everyone on the webinar today about that topic.
Great, and we're thankful to have you both with us today, and thanks again to your law firm, Miles and Stockbridge. You had both of their contact information, and here's now the link to the law firm site. So again, our topic today is employment law issues for government contractors in the face of COVID-19. And so we will kick it off here, and I'm going to put myself on mute and hand the floor over to you guys.
Great, thank you. So as Pete said, we're about 6 weeks into the stay-at-home order, and it's a bit uncertain when the restrictions will be lifted and what it will look like in the workforce after the restrictions are lifted. So many employers have been facing and are facing a decrease in work as a result of COVID-19, certainly a decrease in revenue, and need to consider whether or not they need to maintain their workforce in their current numbers. So we're going to talk about 3 things that an employer can do to manage a decreased need for employees. The first is furloughs, then layoffs, and the last is reduced hours and salaries. Next slide. So the first one is furloughs. So what is a furlough? A furlough is somewhat of a vague concept. It doesn't have specific limitations, but it's generally mandatory time off without pay that's initiated by the employer with a general expectation that the employee will return to work at some point in time in the future. It is not job protected leave, and the employer can decide at the end or at any point in time to need the employee. So for government contractors, the first question is, can you furlough your employees on a government contract? In order to answer that question, you really have to look to the terms of your government contract to see what it says. Do you have key employees? Do you have staffing levels that must be maintained? Do you have deliverables in your contract that can only be met if the employee continues to work? During COVID-19, government employees are supposed to be permitted to work remotely as much as possible, but that doesn't necessarily apply to government contractors. It's a little ambiguous. So there may be instances where the employee can't access data or the government system due to, among other things, security issues. So we would suggest that you work with your contracting officer to ensure that as many of your employees as possible are able to work remotely to the extent feasible. If you decide that you want to initiate some furloughs, we suggest that you develop objective criteria for selecting who is going to be furloughed. There are going to be a lot of employment and other litigation claims that arise from this COVID-19 situation, and you want to avoid claims of discrimination, disparate impact, and disparate treatment and adverse impact. So you really should treat a furlough the same as a reduction in force or a layoff. If you're furloughing less than the entire workforce or an entire department or all employees in a certain job category or title, we suggest that you make sure that there are legitimate business reasons that are preferably objective, that can be documented, that support your determination that one employee should be furloughed and another employee is spared furlough. And most importantly, you should document your reasons now. This will show that you thought about all of the criteria, and it will be available to you in the event that somebody disputes why they were selected for furlough as opposed to someone else. You should also look at the use of PTO while on furlough. You should look at the terms of your PTA policy. Can they use it? Are you going to advance leave during the furlough? And are you going to require your employees to use their PTO leave while on furlough. Those are all issues that are personal to each employer. Additionally, the issue is whether insurance, health insurance in particular, will continue during a furlough as if the employee was actively employed. Again, this is going to depend upon the terms of your insurance contract. So we suggest that you check with your insurance company or broker. Generally speaking, when an employee is furloughed, their health insurance will continue or can continue for some period of time. But if this situation lasts more than a month or two, the insurance company could take the position that this is equivalent to a termination and the employee should go on COBRA. So again, you need to talk to your insurance company to make sure you know what is going to happen if you furlough your employees. There are also some nuances for non-exempt and exempt staff. For the non-exempt staff, they're hourly employees and they're paid when they work, which was easier to monitor when people came to the office. You could have them clock in and clock out. You could see when they are working. That you don't have that visibility when someone is working remotely. So you need to make sure that hours worked are documented because you only want to pay for hours worked. With respect to exempt staff, they need to have exempt duties and be paid on a salary basis. And what does that mean? That means that they are paid regardless of the quality or quantity of the work performed during a pay period. So you don't want to pay to furlough an exempt employee after they have performed some work during the week, because then you would be on the hook for paying them their entire pay period. So we suggest that you start the furlough before the employee has worked during the week. If your work week starts Monday morning, furlough them starting Monday morning. And you need to direct all employees, exempt and non-exempt, not to work when on furlough, including sending emails. If people are sending emails and you receive them, you have some notice that they are working, and that can create liability for paying them during this period of time. Next slide. Additionally, there are potential WARN Act issues related to a furlough. A furlough over 6 months in duration triggers the WARN Act. There are also state WARN Acts that have lesser requirements. But basically, the federal WARN Act applies if you have 100 employees and you furlough over 50 employees and a third of the workforce, or you have a plant shut down for 6 months or longer. And what happens under those circumstances? Well, you have to give 60 days advance notice. That's obviously not going to be feasible in this current environment. So there are some exceptions. Some have suggested that COVID could be treated as a natural disaster. I don't know that that exception really applies. The closest exception, or the one more on point, is that the circumstances of COVID were not reasonably foreseeable. Certainly, people didn't know 60 days before the stay-at-home orders that this is what was going to happen. So there are exceptions to the WARN Act. They don't excuse you from providing any notice. You need to give notice, even if the circumstances were not reasonably foreseeable, as soon as possible, as soon as you have actual notice. The next issue to think about is unemployment. We're going to go into in a little more detail, and the CARES Act Paycheck Protection Program. Next slide. The next thing to consider is layoffs. A layoff is generally a permanent situation. It's a termination, unlike a furlough, which is generally for a specific period of time. Like furloughs, there are potential WARN Act implications and state WARN Act issues. Like furloughs, you should develop your objective criteria for selection. Another issue that comes up in layoffs that isn't necessarily at play with furloughs is the cashing out of PTO. This is a matter of state law and contract law. Some states require payment of PTO at termination. Maryland generally prohibits forfeitures. Other states say that whether or not you have to pay unused accrued PTO at termination depends upon your policy. So look at your policy to see what it says. And if you don't have a policy, this might be a good time to create one. Also, since this is a permanent termination, it triggers COBRA. So you'll have to give out your COBRA notices. And again, you have to think about unemployment. Next slide. The third most common way to manage a decreased need for employees is reduced compensation. Some states require advance notice. For example, Maryland requires notice of one pay period in advance when you're going to reduce an employee's pay. Beware of wage determination issues. If you have a wage determination as a government contractor, you can't reduce your wage below the wage determination for those SCA or DBA employees. You should also be aware of Fair Labor Standard Act issues. You need to make sure that you're paying your exempt employees the minimum salary so that they can still be considered exempt, and minimum wage for non-exempt employees. With respect to exempt employees, as I indicated, they have to be paid on the same a salary basis, which means they get the same salary regardless of the hours worked a week. Does that mean that you can't reduce an exempt employee's salary in this time when there's not enough work for the employee to do? No, that's probably not what it means. The salary basis is designed to prevent an employer from watching the clock and avoiding paying wages or overtime by requiring that a same set salary would be paid for each pay period. And it recognizes that sometimes an employee is going to work a little more, sometimes an employee is going to work a little less, but we're not watching the clock. But if an employee is not going to be working his normal schedule on an ongoing basis, it's probably okay to reduce the salary for a set period of time until your operations ramp up again, and you can increase the salary when the crisis is over. But you have to be careful. This should be done on a one-time basis, and if you raise or lower salaries on a more frequent basis, you may be considered to be treating your employee as a non-exempt employee and risk the employee being classified as a non-exempt employee entitled to overtime. And then again, as with the other two, you have to consider unemployment. Next slide. So with unemployment, the rules have changed during COVID-19. It's more important now than ever to understand what employees are eligible to receive from unemployment, so you can factor that into your decision about how to manage your employees' continued employment. Unemployment benefits are determined by the state. Each state has their own weekly rate. DC has a maximum of $425, Virginia's maximum is $378, and Maryland $430. Under the Family First Coronavirus Response Act, FCRA, it provides incentives to employers to assist employees in obtaining unemployment benefits. For example, usually the applicant has to wait 1 week before they're entitled to benefits. That 1 week waiting period has been waived. Also, many states have waived the requirement for a person to look for work because right now it's difficult, if not impossible, to find a job. And significantly, the CARES Act provides an additional $600 a week for employees who qualify for any unemployment, and that is on top of the state benefits. There's no limitation based on the usual earnings or hours. Everyone who qualifies for unemployment under state law is entitled to an extra $600 a week under the CARES Act. Also, full-time and part-time employees are eligible for the additional $600. It is not prorated. Further, under the CARES Act, individuals who are getting unemployment get an additional 13 weeks of the extra $600 after the state unemployment ends. So you get your state weekly amount, let's say $378 for Virginia, plus $600, so $978 during the 26-week state unemployment period. And then after the state unemployment period ends, you still get an additional $600 of CARES Act money for an additional 13 weeks. So you can receive up to 39 weeks of unemployment right now due to COVID. And it's important to note that an individual can make more in unemployment than he or she was paid for working. So many employers are concerned that this is a disincentive to working, or furloughed or laid off from returning to work. And I have had clients call recently saying that employees are not willing to come to work and they'd rather take the unemployment because right now it is generous, or more generous than it has ever been. Additionally, federal benefit includes many who are not usually covered by unemployment. Right now, they're accepting unemployment claims from independent contractors and the self-employed, again, all due to COVID. And the federal benefits have a list of reasons that make someone eligible for the $600 that are different and more relaxed than the normal unemployment rules. Next slide. So now we're going to talk about the Family First Coronavirus Response Act, and in particular, the two new leave provisions that are in that act. The first one is Families First Coronavirus Response Act, EPSL, Emergency Paid Sick Leave, and the second is Emergency Family Medical Leave Act, EFMLA, which is an extension of the FMLA. This law came into effect on April 1, 2020, and it sunsets December 31, 2020. So it's something that all employers are going to have to deal with at least until the end of the year. It provides for tax credits equal to the amount of paid leave provided. So employers are not supposed to have to go out of pocket for this leave. They'll get a tax credit dollar for dollar for the amount of leave that they provided. It is not retroactive. Leave and tax credit provisions do not apply for before April 1. So if you gave your employees additional leave before April 1, you're not going to get a tax credit for it. And it also won't count against the amount of leave you have to provide your employees. It doesn't apply to employees who are laid off or furloughed. So once somebody's off payroll, they're not entitled to this leave anymore. And there were final rules issued on April 1, which was the day that the law went into effect. So it gave employers pretty much no advance notice of what it was going to require. And there have been several clarifications since. Next slide. So the EPSL, we're going to go through the basics. It applies to private employers with fewer than 500 employees and all public employers, but there's an exception for healthcare workers. Employees are eligible from their first day of employment, and that includes full-time employees, part-time employees, temporary employees, and full-time employees are defined as those who work at least 40 hours a week, and they must be provided 2 weeks up to 80 hours of paid leave if they need to miss work and are unable to telework for a qualifying reason. And we're going to talk about what those qualifying reasons are. The part-time employees are entitled to 2 weeks prorated paid leave. So anyone working under 40 hours a week, they're going to get a prorated amount of leave. And paid leave represents a full day of pay at the employee's regular rate of pay that's capped at $511 per per day if the employee is ill or quarantined, and for leave taken because someone needs to care for someone else, paid leave is 2/3 of a full day's wage, capped at $200 per day. Significantly, this is in addition to any paid leave the company provided prior to April 1. And for government contractors, the 80 hours of the FCRA emergency paid sick leave is in addition to the 56 hours of paid sick leave the government contractors must provide under Executive Order 13706. Again, it's in addition to whatever leave you provide or required to provide. Next slide. There are 6 reasons for taking EPSL leave. The first 3 deal with the health of the individual employee. The first one is that the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19 that prohibits the employee from doing work it would otherwise be able to do. The second is the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. And the third, related to the health of an individual employee, is that the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. The next 2 reasons for taking EPSL deal with the care of others. You can take EPSL if the employee is caring for an individual who is subject to an order described in one above, the self-quarantine or isolation order, or has been advised to self-quarantine due to COVID-19 concerns in number 2. And they can take EPSL leave if the employee is caring for a son or daughter of the employee if the child's school or place of care has been closed, or the child care provider of the son or daughter is unavailable due to COVID-19. And the last reason for taking EPSL is a catch-all, and nobody seems to know what it was intended to cover, but it says the employee is experiencing any other substantially similar conditions specified the Secretary of Health and Human Services in consultation with the Secretaries of Treasury and Labor. Next slide. So now we're going to talk about the second new leave, and that's the emergency FMLA. Again, it applies to private employers with fewer than 500 employees and certain public employers, with an exception for healthcare workers. It also applies to full-time, part-time, and temporary employees. And unlike the old FMLA, employees only need to be employed for 30 days before they're entitled to this emergency FMLA. There is no 12-month threshold. There's no 1,250 hours worked like with the regular FMLA. And the 30 days doesn't start if the employee is terminated and rehired. They don't have to meet the 30-day requirement once they return. The first 2 weeks of the EFMLA is unpaid. The employee may use emergency paid sick leave or PTO if they choose. The remaining 10 weeks are paid at 2/3 the regular rate, capped at $200 a day. That's the same as the EPSL. Next slide. Unlike the EPSL, there's only one reason an employee can take EFMLA: if the employee is caring for a child whose school or daycare is closed, or the child's health, or the child care provider of the son or daughter is unavailable due to COVID-19 precautions. So it's much more limited than the emergency paid sick leave. Next slide. That actually ends my part of the presentation, other than the questions. And now I'm going to turn the mic over to Pete.
Great, thank you, Meryl. Meryl just talked about a lot of requirements that are placed on employees, on employers for contractor employees. What I'd like to talk about now is some special reimbursement scheme in place for government contractors to place employees in a ready state if they cannot work at the government work site. And that's Section 3610 under the CARES Act. Section 3610 allows for reimbursement of costs, and that's an important aspect. It only allows for reimbursement of costs to place contractor employees in a ready state, and that's been interpreted by various agencies to mean in a paid leave status when access to the government-approved work site is denied or impossible due to the COVID-19 pandemic. The policy behind that is to ensure that that talent is not lost, but that rather those contractor employees are able to return to the work site in an expeditious manner once access to the government-approved work site is restored. The first important thing to know about Section 3610 is that the Act is discretionary. Agencies are not required to grant reimbursement under Section 3610. The guidance that has been issued by agencies is very clear that each agency has the discretion to determine who is eligible to get Section 3610 funding. Some agencies have taken a fairly wide, given fairly wide access to Section 3610 reimbursement, and those generally tend to be in the intel community. Other agencies have taken a contract by contract, contracting officer by contracting officer basis. Section 3610 allows only for the reimbursement of costs. No equitable adjustment of fee, profit, or markup is authorized under the statute. At least no equitable adjustment upward of fee, profit, or markup for the contractor. Only the costs of providing paid leave are allowed under Section 3610. In addition, contractors may not request more than 40 hours of paid leave per week per employee. Now, that is the case even if the contract allows, or even if it mandates compensated or uncompensated overtime. So for your exempt employees, they should know that they're only going to get 40 hours. If they regularly expect or receive time and a half overtime, that's not going to be available to them under Section 3610. In addition, if you have exempt employees who regularly work more than 40 hours, they are only going to be able to get the 40 hours per week of reimbursement costs. Next slide, please. There are a variety of other limitations that are placed on the reimbursement available under Section 3610. One of the big ones is that no additional funds have been authorized by Congress to pay for Section 3610 reimbursement. There's a reference in the statute under Section 3610 that any other funds made available under the Act are available, or funds that are otherwise available under other appropriations to the agency are authorized for Section 3610 reimbursement. The problem is there were no other funds authorized by Congress in the CARES Act for such reimbursement. Therefore, only the funds that are currently available to the agency to pay the contract, or that would be available to the agency to pay the contract if the contract grew for some reason, are available to pay for Section 3610 reimbursement unless Congress subsequent to now authorizes an additional appropriation, which we believe is highly unlikely. So the agency has to find the money, and that will affect their ability or desire to authorize Section 3610 reimbursement. The rate for reimbursement is limited to what is called, quote, the lowest contract billing rate for the specific applicable work categories for which reimbursement is requested. A lot of the guidance that agencies have been putting out has been to interpret that phrase that's in quotes there. And basically how that has been interpreted is, let's say you have two different employees that are in the same labor category. And for some reason, one of those employees has been authorized an upward adjustment from what the billing rate is for that labor category. You can only request from the agency the lower of the two, the lowest contract billing rate for that work category. Here's where a lot of questions have been coming out from contractors, and I think we may have a couple of them at the end of this presentation. There is a requirement in Section 3610 that a contractor must reduce their Section 3610 request or pay back any Section 3610 reimbursements that they get to the extent any other relief under the CARES Act is provided. This includes forgiven paycheck protection program loan amounts. Based on some updated guidance that was provided last Friday by Defense Policy, the DoD has interpreted this to mean that your company will be required to give back any Section 3610 reimbursement that's applicable to forgiven PPP loan amounts, but not any 3610 reimbursements that are applicable to loan proceeds that are not forgiven. In addition, the paid leave must be taken after March 28th, 2020 and before September 30th, 2020, unless there's an extension to the authority that's provided by Congress in a subsequent legislation. So a lot of contractors have had to give paid leave in the period in between when the stay-at-home orders began, which was somewhere around St. Patrick's Day, and March 28th. That portion of time is not going to be compensable. Next slide, please. Some of the questions that we've been getting from clients involve inconsistent implementation of Section 3610. There has been no government-wide regulations and little to no government-wide implementation guidance. There has been a reference to Section 3610 by OMB, but no real guidance. Therefore, each agency has been responsible for implementing 3610. Where this is causing confusion is where contractors may provide support to more than one agency. They're having to follow more than one set of guidelines, some of which are inconsistent with each other. And indeed, many times, the implementation guidance that agencies themselves are putting out may be internally inconsistent. I have some examples up on this slide, but there are many others. For example, the Department of Defense has put out guidance that says, consistent with the plain language of the statute, that a request for reimbursement must be in the form of a request for equitable adjustment and modification to the contract. The Department of Defense guidance states that each contracting officer must exercise his or her discretion on whether it's in the interest of the government to grant or not grant Section 3610 reimbursement. Of course, because the Department of Defense is not providing top cover to the contracting officer or providing any kind of criteria that the contracting officer should follow on whether to exercise this discretion or not, that may mean very inconsistent application amongst defense activities, and maybe even inconsistent decisions on whether to grant 3610 reimbursement in the same defense activity, but with different contracting officers. DoD has stated a preference for indirect costs versus direct costs. However, it has not stated that they are mandating that Section 3610 reimbursement be treated as an indirect cost. That has caused a lot of confusion along the contractor community and is currently the basis of a lot of requests for clarification that various industry groups have been providing. The DoD has also issued a FAR deviation, which issues a renewed cost principle regarding 3610 reimbursement. The Maryland Procurement Office and other intel agencies have put out some differing guidance, which is confusing, especially for the Maryland Procurement Office, because it incorporates the conflicting guidance from DoD. What MPO has said is that contractors should only bill direct costs of providing the paid leave. The MPO has also said that the contractors who are requesting Section 3610 should invoice directly for costs. They have not stated how the contracts will be modified, but we suspect, based on the method that they're choosing, that those invoices and payments against those invoices will likely be considered to be contract financing payments that will have to be settled at the end of the year through an incurred cost proposal. The GSA has issued a separate FAR deviation that treats Section 3610 a little differently. An open question is that, as part of that FAR deviation, GSA has issued their own cost principle for Section 3610 reimbursement, which is slightly different than DoD's cost principle. An open question is if DoD is issuing an order under a GSA contract, such as a federal supply schedule or a government-wide acquisition contract, whose FAR deviation or whose cost principle takes precedence. That answer is unclear. Next slide, please. Because of this inconsistent implementation, inconsistent guidance, and differences in treatment, a lot of contractors are asking, how can we accept this reimbursement and manage the risk behind this inconsistent treatment? One of the big pieces of advice that we have generally given is to document your decisions as much as possible. You should document evidence that the work site was approved by the government, evidence that the work site is not available, evidence that paid leave was not charged to a personal PTO account. You should document evidence that telework or remote work was not available to employees, because if telework or remote work is available, then the government should be charged under the contract and not under Section 3610. Assume that an audit will happen. There's been a lot of rhetoric lately from the SBA and from various agencies regarding all of the CARES Act provisions and that audits will happen. Assume that your decisions on Section 3610, your invoices, will be audited, even if your contract is firm fixed price and you're not normally subject to an audit. Stay up to date on agency 3610 guidance. It changes weekly and sometimes changes daily. For instance, the DoD guidance that I cited earlier has been generally changing on a weekly basis. And I would expect today some updated 3610 guidance to be released on the DoD DPC website. And track any covered credits under the CARES Act, such as paycheck protection loan forgiveness, CARES Act tax credits, FFCRA tax credits, and make sure you inform the CO that you've received these amounts immediately, and make arrangements to pay back an appropriate amount of 3610 reimbursement. Next slide, please. With that, we'll go into the questions that we received.
Super. Thank you, Meryl, and thank you, Pete. I'm going to read off the questions. I believe we've got about 14. And the first one will go to you, Pete. We are a federal contractor and will be billing under the CARES Act for some of our employees. Can we submit for CARES Act PPP, loan forgiveness for our non-CARES Act personnel or for the non-CARES Act time? For example, a person bills 40 hours per week for 8 weeks not under the CARES Act, or a person bills 30 hours per week non-CARES Act and 10 hours per week CARES Act for 8 weeks. Can we use the non-CARES Act time to request loan forgiveness, or would that be considered double dipping?
That is a good question and a fairly straightforward question for which, unfortunately, there's not a straightforward answer. Let me explain. All the CARES Act says under Section 3610, all Section 3610 says is that you have to provide, you have to lower your reimbursement for any amount that is provided to the contractor under a different section of the Act. So if you were to get loan forgiveness in an amount for a certain worker that's allocable to the contract, then you would have to provide a credit back of that 3610 money. That's pretty straightforward. However, there has been some rhetoric from the SBA and from the Treasury Department and some new guidance that says that people taking paycheck protection program, or companies that take paycheck protection program proceeds, and that who apply for the loans must not have access to liquidity elsewhere. Section 3610 reimbursement, if it's received, as a form of liquidity. Now, some companies didn't know if they were going to get Section 3610 reimbursement before they applied for their paycheck protection program loan. That if you were lucky enough to get a paycheck protection program loan, you weren't one of the many who were shut out, and you're considering taking CARES Act Section 3610 reimbursement, you should really seek out the advice of counsel who are experienced in this area, because there are a lot of risks. Some of those risks are legal, and some of them are frankly political and reputational, based on some of the statements that policymakers have been making in the last week.
And
next question.
Thank you for that. Okay, great. And so number 2, we're going to go over to you, Meryl, for this one. Question reads, we have 5 people in our company. I'm assuming those will be full-time. Are we required to provide the leave and benefits in the FFCRA? Obviously, Families First Coronavirus Response Act. Meryl?
Yes. So the answer is a typical lawyer answer. It depends. The exemption, there's an exemption for employers with 50 or under employees, but it's only available for emergency paid sick leave used to care for a child with a daycare or childcare situation, or EFMLA again for childcare. So there's no exemption related to the other 5 EPSL reasons. And so if your employee is requesting leave to take care of childcare due to school closing or loss of childcare, you may be exempt.
Okay, super. We'll move to the next question. Number 3 reads, I understand that there is an exemption from FCRA for employers with under 50 employees. I employ fewer than 50 employees. Am I automatically exempt from the FCRA, which is similar to the previous question, but Meryl, I'll let you answer here, please.
Right. So this builds on the last question. Is indicated the exemption is only available for the childcare issue, but the exemption is not automatic. In order to become exempt, the business must determine that providing leave would result in expenses and financial obligations exceeding available business revenues and cause the business to cease operating at a minimal capacity. Or the second reason would be the absence of the employee requesting leave would entail a substantial risk to the financial health or operational capabilities because of their specialized skills. And there's a third reason. There are not sufficient workers available to perform the labor or services provided by the employee requesting leave, and these services are needed for the business to operate at a minimal capacity. So if you fall within one of these 3 categories, you may be exempt. And if you decide that you do fall within one of these 3 categories, I would suggest that you document your decision. Why do you think you meet categories 1, 2, or 3? And this analysis has to be done for each employee requesting leave because it's employee specific and depends upon what they're doing for your company.
Okay, great. Thank you. And number 4, as a federal contractor, am I allowed to take a CARES Act Paycheck Protection Program loan if I am billing against the CARES Act? Pete?
Again, a straightforward question with a complicated answer. Again, the CARES Act Section 3610 only states that the reimbursement that a contractor is otherwise eligible for under Section 3610 must be reduced by any compensation the contractor receives under a different part of the CARES Act. What that would suggest is that if you get a loan, that you can have that loan, but if its amount is forgiven, you would have to pay that allocable amount back of 3610 funds to the agency that pays the 3610 reimbursement. However, in recent days, the SBA and the Treasury Department and policymakers have been providing unhelpful guidance regarding the PPP loan, saying that contractors who are certifying that they have an economic need for the PPP program must not have another source of liquidity. It's very possible that in auditing, that if the SBA were to audit, that they would consider Section 3610 another source of liquidity. They have not been provided any more guidance on that subject. You should also be aware that the Treasury Secretary has stated publicly that any contractor who receives more, or that any company that receives a PPP loan of more than $2 million is going to be audited. Now, we don't know if the government's going to make good on that promise, but that is something that Secretary Mnuchin has stated. So that is one of the risks that you need to consider. You should also consider the fact that the list of those who take both PPP loans and CARES Act loans is likely, or CARES Act Section 3610 reimbursement is likely going to become a matter of public record. Those are risks that you really should consider before participating in both programs. And you would likely benefit from the advice of experienced counsel in this area.
Super, thank you. Good things to think about there. And number 5, can an employee use EPSL if they are afraid to come to work because of potential exposure to COVID-19? Meryl?
Probably not. In this day and age, most employees or many employees are afraid to come to work because of potential exposure. And if we allowed everybody just to give up, businesses could not continue. The employee can't take EPSL just because they're afraid, but if they get a recommendation from a healthcare provider that they should self-quarantine because the employee is particularly vulnerable to COVID-19 and the employee is unable to telework, they could be entitled to EPSL. Also, if the employee is caring for an individual who is self-quarantined at the recommendation of a healthcare provider, and that person is particularly vulnerable, you may need to give EPSL to your employee. So what is particularly vulnerable? It's a little vague, and I'm sure there's going to be litigation after the fact to determine exactly what it entails, but it's generally when an underlying condition makes the person particularly vulnerable, like someone with a suppressed immune system. Also, you should think about what happens after the EPSL is exhausted. If the employee has a serious health condition that would entitle him or her to regular FMLA, you may need to go through the normal ADA analysis and interactive process after the person has exhausted their EPSL.
Okay, great. Thank you for that. And number 6, can an employee receive unemployment if he or she fears coming to work because of COVID-19?
So you would think that the answers would be the same, but they're a little different. An employee may be able to receive unemployment if he fears coming to work because of COVID-19, because unemployment is a question of whether the employee has good reason not to work or telework if work is available. But the CARES Act expands the circumstances under which an employee may be able to collect unemployment due to COVID. And it expands it to include 2 situations where unemployment may, the individual's place of employment is closed as a direct result of COVID, and more significantly, the individual has to quit his or her job as a direct result of COVID-19. So we don't know exactly what the criteria will be for determining whether the individual had to quit his job or her job because of COVID-19. But we think that whether or not the employee will be found eligible for unemployment because he or she felt they had to quit will depend upon the reasonableness of fear. It's going to be a factual inquiry. The unemployment will look at things like, are there COVID cases at work? What actions has the employer taken to ensure social distancing and enhanced sanitary measures under the CDC guidelines? So we suggest if somebody says that they don't want to come back into work due to fears, that you ask them, what else can we do as an employer to make them comfortable coming to work? And if they just say it's just a generalized fear, and you can't convince your employee to come to work, you may want to contest their eligibility for unemployment.
Great, thank you for that. And number 7, please touch on the DoD issued DFARS class deviation on Section 3610 of the CARES Act and 3610 of the CARES Act for FAS and different IDVs, GSA schedules, GWACs, etc., regarding adjustments and reimbursements. Pete?
Great. So this touches on one of the previous slides where I was talking about the inconsistent treatment of, or the inconsistent implementation amongst agencies. And this question really highlights because there is a FAR class deviation with a supplemental cost principle that's been issued by the Department of Defense, and there has been a FAR class deviation issued by the GSA for all of their contracts, including their indefinite delivery vehicles, such as GSA schedules and GWACs. What we don't know is if the DoD issued a class, if the DoD issued FAR clause or cost principle under the class deviation, takes precedence on DoD orders under GSA contracts. Generally, the GSA contract clause would override. However, because it's a cost principle, generally cost principles are considered to be supplementary, such as that if you had a cost principle under the FAR, and then you had supplemental cost principles under the that are specific to the contract, that those have to be read in harmony and together to the extent they can be harmonized. So that is an area where if you have a DoD order under a GSA contract and you're seeking Section 3610 reimbursement, you would benefit from the advice of experienced counsel in this area.
Great, thank you. And number 8, does a governor's order to shelter in place or quarantine entitle an employee for EPSL? Meryl?
The answer to that is, again, it depends. A shelter in place order entitles an employee to EPSL if it prohibits the employee from going to work or teleworking when the employer is otherwise open for business. So if the place of employment is closed because of a government order or for any other reason, the employee would not be entitled to EPSL. And that is because the employee is not working, not because of the order, but due to the fact that the employee's place of employment is closed. So that's the critical inquiry.
Okay, and we'll move to number 9. What documentation can be required to support the need for leave? Meryl?
So the final rule tells you exactly what you can ask for, and you can't ask for anything else. So you need to take into consideration what you can ask under the FCRA and also the tax regulations, because you're going to need documentation to get your tax credit. For anyone who's asking for FCRA leave, you can ask the employee's name, the dates for which the leave is requested, the reason for leave, and ask for an oral or written statement that the employee is unable to work or telework due to a qualifying reason. And the most important piece of that is, when is the employee going to come back to work? Because you don't want to provide an indefinite leave. So you can require an estimated return date, which understandably may change, but you should ask for a commitment by your employees when they're coming back. When someone is asking for leave to self-quarantine or due to an isolation order, or to care for someone subject to an isolation or quarantine order, you can ask the name of the government entity that issued the quarantine order that the employee or the person being cared for is subject to, so you can make it a determination whether or not it applies. If the leave is based upon a recommendation of a healthcare provider to self-quarantine or to care for another, you can ask for the name of the healthcare provider who advised the employee or the person being cared for. And if the leave is to care for another whose healthcare provider advised the individual to self-quarantine, you should ask for the age and relationship to the person being cared for. And who you can care for is a bit of an amorphous concept under the FFCRA. It's not defined as someone who's just in your family, like in the FMLA. It's much broader. It's someone with whom you have a personal relationship, so that it would be reasonable or reasonably expected that you care for that person. So it would definitely include an immediate family member. It would include a member of your household. What about a roommate? I think that's somebody in your household, probably that would qualify. A neighbor, it depends on the employee's relationship with that individual. Are they caring for them generally? So it is a factual inquiry as to who this person you can take leave for to care about.
Okay, thank you. And I think we've only got a couple more to go here. Number 10, how can I prove that my work site is government approved and that the work site is not available for purposes of Section 310 reimbursement? Pete?
Thank you. There has been some guidance. The most helpful guidance that's been put out is by the DoD in their frequently asked questions. There is also a definition of government approved worksite in the GSA FAR class deviation. Government approved does not necessarily mean a government worksite. It can be a contractor worksite if that contractor worksite is specified in the contract. It can also be any place that's authorized under the contract. And that's why you need to be able to demonstrate that telework is not available for any employee for which Section 3610 reimbursement is requested. Because if telework is not prohibited and remote work is not prohibited under the contract, then it's possible that telework and remote work could be considered a government approved work site. And that therefore, if you cannot prove that telework is either not feasible or not available, then you wouldn't be able likely to request and keep Section 3610 reimbursement. As for the work site not being available itself, the easiest way is if the contracting officer tells you that it's not available, if they give you a specific direction. If you don't get a specific direction, then you'd want to document through some kind of contemporaneous evidence, maybe a statement from an employee who tried to access the work site, perhaps government websites that would state that certain facilities are not open, any kind of email correspondence that you get from government employees, etc. Those could all serve as evidence that the work site is not available.
Okay, and thank you for that. Number 11, can EPSL be used for more than one reason if the employee doesn't use the full 2 weeks? Meryl?
Yes, if the employee goes out on leave but doesn't use the full 2 weeks of EPSL the first time out, they can bank the unused time, but the total amount of EPSL is capped at 80 hours. So if an employee goes out on EPSL and takes 60 hours for one reason, they're sick, they come back, and now somebody in their household is sick, they can go out again, but they would only have the remaining 20 hours left.
Thank you. And number 12, can an employee receive unemployment if they are not working due to COVID or have a family member with COVID? Meryl?
Yes, they can receive unemployment if the employee is not receiving income because they're sick or seeking a diagnosis of COVID. The person can receive benefits. The employee should first exhaust any paid sick leave offered by the employer because they can't otherwise certify that they're not eligible to be paid. And with respect to seeking a diagnosis, the employee must be consulting a doctor or waiting for an appointment with the doctor. And we all know that doctor's appointments are like gold right now. So a person can be on EPSL while waiting for the doctor's appointment. And the same is true if the employee must stay home to care for a family member with COVID or who is seeking a diagnosis. They should be eligible for unemployment.
Great, and thank you. Number 13, can I take both CARES Act PPP loans and Section 3610 reimbursement for the same employees? What if part or all of the PPP loan is forgiven? Pete?
Sure. This is somewhat touches in a different manner on some of my prior comments. When we first started analyzing the CARES Act PPP program and the Section 3610 reimbursement, there did not appear to be on the face of the statute any prohibition for the same employees being cited, included in the amount certified under the payroll for the Paycheck Protection Program application and Section 3610 reimbursement to place them in a ready state, so long as any amount that was forgiven under the PPP or any tax credit that was provided under the CARES Act was then paid back as a refund on Section 3610 reimbursement. However, some of the statements and guidance that the SBA has been providing in the last week to 10 days, as well as statements from policymakers, create a risk that, in retrospect, the SBA and other agencies may be interpreting those statutes in a more aggressive manner to perhaps prevent the Paycheck Protection Program loans for contractors who have other means of liquidity. And of course, Section 3610 reimbursement would appear to be a source of liquidity. So if you're considering keeping both, and especially if you're considering keeping forgiveness under the PPP, that is something that you should seek experienced counsel on for your particular situation.
Thank you. And number 14, can employees receive unemployment when his hours or pay are reduced? Meryl?
Well, that's a definite maybe. Unemployment is based upon not working or a reduction in hours. So if the employee has pay alone without reduction in hours, it doesn't trigger unemployment. But a reduction of hours plus a reduction of pay could be considered partial unemployment. And the amount the individual can receive in unemployment must be less than the weekly maximum unemployment benefit. So before I mentioned the $378 weekly. So if the employee is receiving more than, that's for Virginia, if the employee is receiving more than the maximum amount of the state benefit, they will not be entitled to unemployment because any amount that the individual receives will be deducted from the unemployment benefit. So if it's not a substantial reduction of hours and pay, the individual, as a practical matter, may not receive unemployment benefits.
Okay, thank you. I believe that may have been yes, that was the last question. So Meryl and Pete, thank you both so much for your time, answering the question, sharing your insights. Obviously lots of good questions, and obviously your contact information is on the earlier slide. So if anybody has additional questions, you can either send them to us at the hello@jennifershouse address that you see on your screen, and we'll forward those to Pete and Meryl, or you can certainly contact them directly. Again, we thank you all for joining us. We will email the MP4 to everyone who is registered and paid once we're able to convert that the recording to an MP4. The slides are on slideshare.net. And again, thanks to everybody for joining us, and thanks Pete and Meryl for sharing your time with us today.
Thank you.
Thank you.